The next stage in government procurement or public procurement is a pre-bid conference, or as we call a pre-bid meeting. Now, as per the General Financial Rules, Rule 173, in case of contracts of any special nature or complex nature, as we have seen in two-stage bidding processes for procurement, especially for procurement of sophisticated and costly work or services or equipment, and where there is a need for specialized expertise and deliberation by the procuring entity, a suitable provision is kept in the bidding document itself for inviting bidders or their official representatives to attend one or more bid conferences or meetings at a particular time and place, and this is done so for the purpose of clarifying issues and clearing doubts pertaining to the bid documents itself. Since this conference is conducted before the bids are evaluated, this is called as a pre-bid conference. Now, the date, time and place of pre-bid conference should be clearly indicated in the bidding document, and this date should be sufficiently ahead of time of the bidding opening date. This is to ensure that the bidders get sufficient time to evaluate the contents of the bid documents. And the records of such conference shall also be intimated to all bidders and shall be exhibited on the website or the portal of the procuring entity where the tender was published. Now, bidders should also be asked to submit written inquiries or queries in advance of the conference. This is to ensure that the procuring entity is given sufficient time to answer these queries in detail. Now, after the conference, the minutes of the pre-bid meeting should include all discussions, including questions and replies, and shall be prepared and approved by the competent authority of the procuring entity and shall be shared along with all the other revised bid documents with the prospective bidders. Now, in case of techno-commercial requirements, such requirements may also be revised if it is considered necessary by the procuring entity, and this shall be issued by way of a corrigendum to the same. An issuance of corrigendum relating to techno-commercial requirements must necessarily follow the rules and requirements stipulated for issue of corrigendum under the General Financial Rules. Now, after the issue of clarifications or modifications to the bid documents, which is consequent to the pre-bid meeting, at least 2 weeks' time should be given to the bidders to submit their bids. This is clearly to give a sense of time to the bidders to ensure that they can make an informed decision while submitting their technical and financial bids. Let's look into the process of submitting bids by the tenderers or the bidders. As has been discussed earlier in the stages of bidding, every bidder or every tenderer is required to submit 2 bids, that is, one which is a technical bid stipulating technical qualifications and requirements, and the financial bid, which generally includes the financial cost or overheads and the price quoted by the bidder. So, various stages involved in submitting a bid until the stage of opening a bid are as follows. When a bidder is required to submit a particular bid, the tender document must necessarily specify the total number of copies that a bidder must submit. That can either be in a single envelope, in duplicate or triplicate. Now, in case the bids are asked to be submitted in multiple copies, then the bidder or tenderer is required to seal the original copy along with each other copy in separate envelopes and duly mark them before posting them. In case the tenderer wishes to withdraw the bid after submitting the tender, they are permitted to do so, and they are permitted to do so along with any substitutions or modifications in writing without forfeiture of the bid security. Now, this can be done provided these are received duly sealed and marked in original and they are up to date and time of receipt of the tender. Now, any such request received after the prescribed date or time of receipt of the tenders will not be considered by the procuring entity. What happens in the case of delayed submissions? Now, the tender received by procuring entity after the deadline stipulated in the tender documents should not be opened at any cost and shall be returned to the bidder or the contractor that submitted it. Now, in case of e-procurement, no submission is allowed after the deadline, and the portal shall provide a lapse in terms of submission of bids. When we look at the process of opening bids, now bids are typically opened by a bid opening committee that is specifically allotted and set up for the purpose of receiving bids by a procuring entity. In case of public bid openings, a record of opening the bids shall be maintained, including the signatures of any bidders present. A bid opening report containing the names of the tenderers, any salient features of the tenders, should necessarily be prepared by the bid opening committee or by the tender opening officers, and it shall be duly signed by them along with the date and time. This is to ensure transparency and accountability in the entire process. In many a case, along with submission of bids, the bidders are also required to submit or provide something called as bid security or earnest money deposit. So what exactly is bid security? Now, as the name suggests, a bid security is a form of security to safeguard against a bidder's withdrawal or alteration of its bid during the bid validity period in case of advertised or limited tender inquiry. This goes to show that in the event any bidder wishes to withdraw its bid to avoid any administrative technicalities or administrative glitches and to ensure security for bids submitted, the bidder is required to give a security which is pre-estimated in the bid documents. The amount of bid security should ordinarily range between 2 to 5% of the estimated value of goods or services to be procured. Now, the amount of bid security should also be determined accordingly by the ministry or department or the procuring entity, and it must be indicated in the bidding documents. Bid securities of unsuccessful bidders should be returned to them at the earliest after the expiry of the final bid validity. The bid security may be accepted in the form of an account payee demand draft, fixed deposit receipt, a banker's check, or even a bank guarantee. The mode of paying the bid security must be provided clearly and explicitly in the bid documents. A bidder's bid security can be forfeited in many a case. Now, what are the situations in which this bid security can be forfeited? A bidder's bid security can be forfeited in any of the following situations. 1. If the bidder withdraws or amends his tender before the bid validity period expires, if it impairs or derogates from the tender in any respect within the period of validity of the tender, if the bidder does not accept the correction of his bid price during the evaluation process, or if the successful bidder fails to sign the contract or furnish the required performance security within the specified period, then in such situations the bid security can be forfeited. This means that the bid security amount will not be returned to the bidder at any cost. When we talk about forfeiting bid security or encashing bid security, a question may arise as to the circumstances where such amount may be encashed. In this regard, the case of National Highways Authority of India versus Ganga Enterprises and another may be pertinent. In this particular case, the facts were such that the National Highway Authority of India issued a tender notice inviting tenders for collection of toll on a portion of highway running through the state of Rajasthan. There were two types of securities to be furnished by the bidders. One being a bid security amounting to Rs 50 lakhs and the other one was a performance security for the contract by way of a guarantee amounting to Rs 2 crores. Now, both of these bids were to be issued in the form of bank guarantees. As per the tender documents or the bid document, the stipulations were such that the bid security may be forfeited if the bidder withdraws his bid during the period of the bid validity, or in case the successful bidder fails within the specified period to furnish the requirement performance security and sign the agreement. So there were two specific and clear stipulations provided in the bid documents. Furthermore, it was also stipulated that the bid shall remain valid for a period of 120 days after the last date of the bid submission. Now, in this particular case, Ganga Enterprises gave the bid but withdrew the same before the expiry of 120 days. Now the contract was not concluded and the National Highways Authority of India proceeded to encash the bid security. Aggrieved by this, Ganga Enterprises had challenged this move by National Highways Authority of India. So the issue before the court was whether the forfeiture of security deposit was within the authority of law or was binding on the contracts between the party. In this case, the court held that it was a settled principle of law that a contract of guarantee is complete and a separate contract by itself. So the law regarding enforcement of any demand bank guarantee is clear, and if the enforcement in terms of the guarantee, then the courts must not interfere with the enforcement of the bank guarantee. So what does this mean in this particular case? In this case, it was clearly stipulated that if the bid was withdrawn within 120 days, or if the performance security was not given, or if an agreement was not signed, the guarantee could be enforced. The bank guarantee was to be enforced before the bid was withdrawn within a period of 120 days. Therefore, in this particular case, it could not be said that the invocation of bank guarantee was against the terms of the bank guarantee itself. This meant that the National Highways Authority of India was entitled to forfeit the bid security and to encash the same, as it was clearly against the express and explicit stipulations in the tender document. Now that we've looked at the general financial rules and the guidelines provided by the Central Vigilance Commission, in the final segment of our discourse on the laws and guidelines applicable to government contracts and processes of public procurement, we will be delving into the guidelines formulated and provided by the Comptroller and Auditor General. Before delving into the guidelines and regulations formulated for the Comptroller and Auditor General, let's look at what the role of the Comptroller and Auditor General is in context of government contracts. As discussed earlier in the previous slides, we have seen that the CAG has been entrusted with the sole responsibility of providing independent and credible assurance in context of public resources and public money. Therefore, under the general financial rules, there has been a specific mandate for every procuring entity that is governed under such rules to ensure credibility of finances used in public procurement. As per the General Financial Rules, Rule 21, there is a mandate to ensure efficient utilization of public funds and public money. It explicitly and specifically states that every officer incurring or authorizing expenditure from public monies for any process of public procurement must necessarily be guided by high standards of financial propriety. This means that every officer should also enforce financial order and strict economy and ensure that all relevant financial rules and regulations are observed by his or her own office, including subordinate disbursing officers. Now, to ensure transparency, accountability, and ethical standards in every transaction in the entire course of government procurement, the General Financial Rules also provides certain responsibilities to procuring entities. As per Rule 175, no official of a procuring entity or a bidder should act in contravention of the Code of Integrity. Now, this Code of Integrity includes the following activities which are prohibited. This may include offering, soliciting, or accepting bribes in context of government contracts or government tendering, misrepresentation or misleading any information, collusion, bidding, or anti-competitive behavior, improper use of information by procuring entities, financial transactions between bidders, officials, or any other officers of the procuring entity in relation to the tender, coercion, threat, or impairment or harm caused to any bidder or officer. The final may also include obstruction to any investigation or auditing of government contracts or processes of government tendering. While there are specific duties for procuring entities and officers of procuring entities, the Comptroller and Auditor General is also vested with certain responsibilities to ensure transparency and accountability in government expenditure and government funding. So where do these responsibilities arise from? Under the Comptroller and Auditor General Duties, Powers and Conditions of Services Act 1971, the CAG is vested with certain responsibilities and duties to ensure that there is mindful expenditure and receipt of all transactions in context of government contracts. As per Chapter 3 of the Act, the Comptroller and Auditor General is regarded to be the sole authority prescribed particularly under the Constitution, with the responsibility of ensuring proper audit of accounts of the Union as well as the states. Therefore, it is the duty of the Comptroller and Auditor General to audit all expenditures, all receipts, and all transactions of the government, of the Union, and of the states and Union territories. Now, this includes government corporations, public sector undertakings, government companies, and any other such institution which may be regarded as a state under Article 12 of the Constitution of India. As we have seen that the Comptroller and Auditor General is vested with certain duties for the purpose of ensuring transparency and accountability in government contracts and public procuring, let's look at the duties and responsibilities of procuring entities vis-à-vis the role of the Comptroller and Auditor General. The Comptroller and Auditor General Regulations on Audit and Accounts, Regulations 2020, specifically applies to procuring entities in context of transactions incurred or transactions carried out for processes of public tendering, public procurement, or executing government contracts. So, to whom do these regulations apply? These regulations apply to officers and staff of the Indian Audit and Accounts Department and all ministries and departments of the central government, the state governments, and the union territory governments, as well as bodies, authorities, and enterprises to which audit and accounts jurisdiction of the CAG applies. This means that all institutions who are regarded to be a state and who are regarded to provide information of their receipts, their expenditure, and transactions involving public money coming out of the public exchequer are required to comply with the regulations on audit and accounts. So, how do the procuring entities comply with these regulations in providing their audits? Simply put, as per Regulation 5 of these regulations, there are three kinds of audits required to be provided by procuring entities, and they are financial audits, compliance audits, and performance audits. So, what are financial audits? Financial audits typically relate to whether an entity's financial statements are properly prepared and whether disclosures are made in accordance with prescribed formats given by the Comptroller and Auditor General's office. As the name suggests, financial audits clearly relate to finances and financial transactions incurred or carried out by procuring entities. The second category of audits are compliance audits. As the name suggests, these audits pertain to compliance in relation to given transactions. So they relate to whether a given subject matter complies in all material respects with applicable laws, rules, regulations, codes, and general principles governing public financial management and the conduct of public officials. Compliance audits specifically relate to the manner in which certain transactions are required to be carried out under a given law or guideline. The third category of audits are performance audits. Now, performance audits are independent and objective and reliable examination of whether certain government entities, institutions, operations, programs, funds, or activities are operating in accordance with principles of economy, efficiency, and effectiveness, and whether there is room for improvement. So, performance audits generally relate to the efficiency, efficacy, and economy of the manner in which transactions relating to government contracts are carried out. As we have seen in the 5 R's of the CVC manual, it is pertinent for every procuring entity to comply with right quantity, right quality, right source, right price, and right time and place of carrying out government contracts. So, performance audits generally relate to whether such 5 R's have been complied with. In the final limb of our discussion on the compliances under the regulations pertaining to the Comptroller and Auditor General, let us look at the duty of procuring entities in relation to the regulations on audit and accounts. As per the Regulation 33 of the 2020 regulations, every procuring entity is duty bound to provide certain information to the Comptroller and Auditor General in context of certain transactions or certain expenditures and receipts pertaining to public procurement or tendering. Under Regulation 33, auditable entities are compulsorily required to provide complete access to all IT systems, platforms, or documents used for budgeting, accounting, procurement, and other such aspects of financial management to ensure complete access to financial transactions of the government or procuring entity, including all sanction orders, appropriations, reappropriations, surrenders, book adjustments, receipts, bills, vouchers, grants, so on and so forth. This should ensure complete traceability of each transaction up to the ultimate spending unit, that is to the final transaction, and thus this shall be made available for audits including financial, performance and compliance audits. In addition to this, quarterly statements of all contracts entered into by procuring entities in the preceding quarter need to be sent or made available to the Comptroller and Auditor General's office by the auditable entity within the first fortnight of the next quarter. So this goes to show that every procuring entity must necessarily provide quarterly statements over and above the annual statements required to be provided in context or in the backdrop of transactions relating to certain tenders. With this discussion, we come to an end on our discourse on the laws, guidelines, and the general legal framework relating to government contracts, tendering, and public procurement in India.